Have you ever worked extra hours and wondered, do I really qualify for overtime pay? Maybe you've stayed late, covered extra shifts, or worked weekends, only to see the same paycheck with no overtime bump. It's one of the most common workplace questions in the US, and the answer isn't always simple. Here's the truth. Under federal law, most employees are entitled to overtime pay when they work more than 40 hours in a week. But there are key exceptions based on how you're paid, the kind of work you do, and sometimes even the state you live in. Employers often misunderstand or sometimes misuse these rules, leaving workers confused or shortchanged. In today's video, I'll break down exactly who qualifies for overtime and who doesn't under the law, with real examples and clear rules, so you'll know if those extra hours should mean extra pay. Part 1. The General Overtime Rule, FLSA. At the federal level, overtime is governed by the Fair Labor Standards Act, FLSA. The basic rule is straightforward. If you are a non-exempt employee, you must be paid 1.5 times your regular rate of pay for every hour worked over 40 hours in a single work week. Let's unpack that. Non-exempt means you're not excluded from the law's overtime protections. Most hourly workers fall into this category. So, if you earn $20 an hour and work 45 hours in a week, you should receive $20 per hour for the first 40 hours and $30 per hour for the 5 hours of overtime. Overtime is calculated by the work week, not the day. That means if you work 12 hours on Monday, but only 30 total for the week, you don't get overtime under federal law. However, some states, like California, do require daily overtime after 8 hours in a single day. We'll come back to that later. Another important point, salaried doesn't automatically mean exempt. Many employees are told, you're salaried so you don't get overtime. But under the law, what matters is not just your pay structure, but also your job duties and salary level. A salaried worker who earns less than the federal threshold, currently $684 per week, about $35,568 annually, is generally still entitled to overtime if they work more than 40 hours per week. This is where confusion often happens. Employers may misclassify workers as exempt to avoid paying overtime. For example, calling someone a manager while they spend most of their time stocking shelves doesn't automatically make them exempt. The law looks at actual job duties, not just job titles. So, the general rule is this. Unless you are specifically exempt, you qualify for overtime pay once you cross 40 hours in a week. It doesn't matter if you're part-time, full-time, hourly, or salaried below the threshold. If you're non-exempt, those extra hours are worth extra money. Part 2. Exempt employees. Who does not qualify for overtime? Now that we've covered the general overtime rule, let's talk about the exceptions, also known as exempt employees. These are categories of workers who do not qualify for overtime pay under the Fair Labor Standards Act, FLSA, even if they work more than 40 hours a week. The most common exemptions are called the white-collar exemptions, and they fall into 5 main categories: executive, administrative, professional, outside sales, and certain computer employees. Let's break each one down. 1. Executive exemption. To qualify, your primary duty must be managing the enterprise or a department. You must regularly supervise at least 2 other employees, and you must have real authority in hiring or firing decisions. So, a store manager who directs staff and makes decisions about operations might be exempt. But a shift supervisor who mostly stocks shelves or runs a cash register may not actually meet the test. 2. Administrative exemption. This applies if your primary duty is office or non-manual work related to management or general business operations, and if you exercise discretion and independent judgment on significant matters. Think of HR staff, compliance officers, or certain analysts Routine clerical workers, however, usually don't qualify for this exemption. 3. Professional exemption, often called the learned professional category. This covers jobs that require advanced knowledge in a field of science or learning, usually obtained through higher education. Examples include doctors, lawyers, engineers, or teachers. There's also a creative professional category for roles requiring invention or artistic talent, like certain writers, actors, or designers. 4. Outside sales exemption. If your primary duty is making sales and you regularly work away from your employer's place of business, you may be exempt. For instance, a salesperson traveling door to door or meeting clients off-site often qualifies. Inside salespeople, like call center workers, generally do not. 5. Computer employee exemption. This is for certain highly skilled computer professionals, like software engineers or systems analysts, who meet specific duty and pay requirements. Basic IT support staff, though, are typically non-exempt. All of these exemptions also require that the employee be paid on a salary basis of at least $684 per week. As of now, if you don't meet both the salary threshold and the job duty test, you're not exempt. Employers often get this wrong, sometimes by mistake, sometimes intentionally. Misclassifying workers as exempt to avoid paying overtime is one of the most common wage violations investigated by the U.S. Department of Labor. So remember, just being salaried or having a fancy title like assistant manager doesn't automatically make you exempt. The law looks closely at what you actually do. If your job doesn't clearly meet the exemption tests, you likely qualify for overtime pay. Part 3. Hourly workers, part-time, employees, and common misconceptions. Most hourly workers assume they qualify for overtime, but let's clear up some of the confusion that often surrounds this issue. First, if you're paid by the hour and are considered a non-exempt employee, you almost always qualify for overtime once you work more than 40 hours in a work week. It doesn't matter if you're scheduled for part-time or full-time hours. What matters is the total number of hours you put in during that week. For example, a part-time employee who usually works 25 hours per week might be scheduled for 50 hours during the holiday season. Those extra 10 hours beyond 40 must be paid at time and a half. Being part-time does not exclude you from overtime rights. A common misconception is that overtime is daily, but under federal law, overtime is calculated weekly. If you work 12 hours on Monday but only 30 hours total by the end of the week, you don't qualify for federal overtime. However, some states, like California, require daily overtime after 8 hours in a day and double time after 12 hours in a day. That's why knowing your state law is just as important as knowing the federal rule. Another misunderstanding comes from flat, daily, or weekly rates. Some employers tell workers, you're paid $120 per day, no matter how many hours you work. But if those hours push you over 40 in a week, that flat rate doesn't cancel your right to overtime. The Department of Labor has made clear that pay must be recalculated to ensure the worker receives at least 1.5 times the regular hourly rate for overtime hours. For tipped workers, like servers and bartenders, the same rule applies. If your combined tips and wages meet minimum wage requirements, you still get overtime pay for hours over 40. Overtime is based on your regular rate, which must include both your base wage and any tip credits the employer takes. Another issue is misclassification. Some employers label workers as independent contractors when, in reality, they should be treated as employees. Contractors generally don't qualify for overtime, but if your employer controls your schedule, provides tools, and directs your work, you may legally be an employee entitled to overtime protection. Misclassification is a hot topic in industries like delivery, ride-sharing, and construction. So, here's the takeaway. If you're paid hourly and work more than 40 hours in a week, you almost certainly qualify for overtime. Part-time status doesn't take that away. Flat daily rates, don't erase it, and even tipped workers qualify. Don't let misconceptions or misclassification cheat you out of pay you're owed. Part 4. Special industries and state variations. Overtime rules don't apply the same way in every industry. The Fair Labor Standards Act, FLSA, has special provisions, and many states add their own twists. If you work in healthcare, law enforcement, agriculture, or certain service industries, your rights may look different. Healthcare workers often have unique schedules. Under the FLSA, hospitals and residential care facilities can use a 14-day period instead of a 7-day workweek to calculate overtime, as long as employees receive overtime after 8 hours in a day or 80 hours in 2 weeks. This recognizes that nurses and aides often work long shifts but irregular weekly hours. Some states, like California, also impose daily overtime, so a nurse working a 12-hour shift may qualify for 4 hours of overtime in a single day, regardless of the weekly total. Law enforcement and firefighters are covered by special overtime rules, known as the 7K exemption. Instead of a strict 40-hour workweek, they can have longer work periods of up to 28 days before overtime kicks in. For example, police officers may only receive overtime after 171 hours in 28 days, and firefighters after 212 hours. This reflects the unpredictable shift-based nature of their jobs. Agricultural workers are another group often excluded. Under federal law, many farm workers are not entitled to overtime at all. This exemption dates back to when the FLSA was passed in 1938, and agriculture was treated differently. However, states like California and New York have moved to close this gap by phasing in overtime pay for farm workers. In California, for example, as of 2022, agricultural employees generally earn overtime after 8 hours a day or 40 hours a week, similar to other industries. Seasonal and recreational workers may also be exempt. For example, employees at small amusement parks, summer camps, or seasonal ski resorts can be exempt from federal overtime rules if certain conditions are met. Then there are the state variations. We've already mentioned California's strict daily overtime and double time rules. Colorado also has its own overtime and minimum pay standards order, which requires overtime after 12 hours in a single day. In Alaska and Nevada, employees must be paid daily overtime after 8 hours. These state rules are stronger than the federal law and apply to all covered employees within that state. The key point is this: overtime isn't one size fits all. Your industry, job duties, and state of employment can all dramatically change whether you qualify. If you're in healthcare, public safety, agriculture, or seasonal work, it's essential to know both federal exemptions and your state's protections. Part 5, protecting your rights, misclassification, complaints, and record keeping. Knowing the rules is one thing, but protecting yourself when overtime pay is denied is another. Unfortunately, wage theft through unpaid overtime is one of the most common workplace violations in the U.S. The good news is there are steps you can take. The first issue is misclassification. Employers sometimes wrongly label workers as exempt or as independent contractors to avoid paying overtime. Maybe you're called a manager, but you don't actually supervise anyone. Or you're given a flat weekly salary that doesn't meet the $684 per week threshold. In those cases, you may still qualify for overtime. The Department of Labor looks at your actual job duties, not your job title, to decide. Second, let's talk about record keeping. The Fair Labor Standards Act requires employers to keep accurate records of hours worked. But, in reality, time cards get altered, hours get rounded down, or off-the-clock work is demanded. That's why it's so important to keep your own notes. Write down start times, end times, between breaks, and any off-the-clock tasks you're asked to perform, like closing up or answering emails at home. Your personal records can be critical if you need to prove your hours later. Third, what do you do if you think you're owed overtime? You have the right to file a complaint with the U.S. Department of Labor's Wage and Hour Division, WHD. They investigate thousands of cases each year and can recover back wages for workers. You can also file a private lawsuit, sometimes on behalf of a group of employees, in what's called a collective action. Don't forget about state labor agencies. In states like California, New York, and Illinois, state-level labor departments enforce even stronger overtime rules. Filing at the state level may be faster or provide better remedies, depending on your situation. One important protection: retaliation is illegal. If you complain about unpaid overtime or file a claim, your employer cannot legally fire you, cut your hours, or punish you. The FLSA and state laws protect you from retaliation. If it happens, that's a separate violation that can increase your remedies. Here's a real-world example. Warehouse workers in New Jersey filed a complaint after being told to clock out, but keep working to finish tasks. The Department of Labor investigated and recovered millions in unpaid overtime wages. Those workers got justice because they documented their hours and came forward. The bottom line is this: if you qualify for overtime, you have the right to be paid fairly for every hour worked. Don't assume your employer's word is final. Learn the rules, keep your own records, and don't be afraid to speak up if something feels wrong. So, do you qualify for overtime pay? For most workers, the answer is yes. If you work more than 40 hours in a week, the Fair Labor Standards Act says you should be paid time and a half. But remember the exceptions. Certain executives, administrators, professionals, outside salespeople, and computer employees may be exempt. State laws can also expand your rights, like California's daily overtime or Oregon's unique rules. The most important thing to know is that job titles don't decide overtime eligibility. Your actual job duties and pay level do. If you think you've been misclassified or denied overtime, keep your own records, ask questions, and know that both federal and state agencies can help recover wages. If this video gave you clarity, hit like, share it with your coworkers, and subscribe for more plain English breakdowns of workplace rights. And let me know in the comments, have you ever worked overtime but not been paid for it?